Rich will not go to jail. I own the city.
The air in the courtroom, usually a dull, sterile blend of dry paper and recycled breath, felt unusually charged, taut with an almost unbearable static electricity. It was the specific, isolating kind of tension that only precedes a public humiliation, a reckoning so absolute that the future itself seems to buckle under the weight of the present moment. Seated at the defendant's table, posture perfect and impossibly composed, was Veronica Thorne. She was the epicenter of this strange magnetic field, projecting an aura of glacial superiority that seemed to repel the very notion of consequence. Her lips, painted a meticulous, expensive crimson, were curled into a slight, almost imperceptible upward tilt, a smirk that spoke volumes without uttering a single syllable.
This was not merely the casual arrogance of wealth. This was the foundational, unwavering certainty of someone who had never genuinely lost, who viewed systems, rules, and indeed the entire concept of public accountability as merely inconvenient suggestions designed for the less fortunate. For Veronica Thorne, daughter of old West Coast money, possessor of trusts that ensured generations of indolence, and mistress of a sprawling Malibu estate, the notion of sitting in a small claims courtroom was itself the ultimate absurdity. She saw this environment, the laminated wood paneling, the slightly frayed velvet of the observer's bench, the heavy, imposing presence of the man behind the bench, not as a place of justice, but as an annoying, temporary diversion, a minor bureaucratic hurdle she was expected to leap with performative disdain. The man who surveyed this tableau from the high vantage point of the judicial bench was Judge Joseph Wapner.
Unlike the defendant, whose expensive attire and studied aloofness attempted to insulate her from the grime of the proceedings, Judge Wapner was a figure defined by his absolute immersion in reality. His face, etched with the unmistakable lines of decades spent dissecting human deceit and aspiration, remained largely impassive. Yet for those practiced in reading the subtle shifts in his demeanor, there was a developing frost in his eyes, a stillness that suggested deep, concentrated appraisal, the kind of professional focus a surgeon applies just before the incision. The case itself seemed minor on the surface, almost laughably disproportionate to the wealth on display. It involved the alleged destruction of a unique, custom-fabricated bronze sculpture, a centerpiece of the plaintiff's modest garden, during a landscaping incident orchestrated by Veronica's sprawling property expansion. The plaintiff, Eleanor Vance, was the polar opposite of Veronica.
Eleanor was dressed in clothes chosen for comfort and necessity, her hands rough from actual labor, and her face open, burdened not by entitlement, but by genuine anxiety and palpable grief over her loss. The claimed value was $47,000, a sum that represented a lifetime of emotional investment and painstaking artistry for Eleanor, but which to Veronica was less than the annual maintenance budget for her primary yacht. This financial chasm was the true foundation of the conflict. Eleanor Vance believed in the fairness of the law. Veronica Thorne believed in the irresistible leverage of wealth. Before even entering this televised arena, Veronica had successfully executed a calculated campaign of exhaustion against the plaintiff.
She had deployed a rotating cast of high-priced legal assistants who buried Eleanor Vance in paper. Motions, delays, subpoenas for irrelevant personal records, all designed to make the pursuit of justice feel exponentially more costly than the original loss. Eleanor had been forced to represent herself, her savings already depleted fighting the procedural warfare Veronica's team had unleashed. Veronica's strategy, built on the cynical axiom that justice belongs only to those who can afford to bankrupt the opposition, had been ruthlessly effective. This preceding victory was the fuel for her smirk, a silent boast that she had already won the war through pure financial attrition, and this courtroom appearance was merely the ceremonial signing of the surrender papers. The crux of the current dispute rested on the issue of negligence and intentional trespass. Eleanor's property abutted Veronica's vast, newly acquired tract of land.
Veronica had hired an enormous construction crew to begin excavating for a new Olympic-sized infinity pool complex, a massive, invasive project that involved heavy machinery operating mere feet from Eleanor's property line. Eleanor maintained that on the morning of the incident, she had personally warned the foreman, detailing the precise location of the fragile bronze sculpture, a family heirloom crafted by her late grandfather. Veronica's defense, articulated with cold precision by her carefully chosen, utterly emotionless corporate counsel, rested on the claim that Eleanor had failed to adequately mark her property line, and furthermore, that the damage was unavoidable, an act of sheer misfortune rather than reckless disregard. As Veronica took the stand, her demeanor shifted slightly from disdain to a theatrical performance of exasperated politeness.
She spoke with a studied vocal fry, her answers clipped, often beginning with a condescending sigh before correcting the framing of the question itself. "Miss Thorne," Wapner began, his voice surprisingly deep and resonant, cutting through the murmuring background noise. "The plaintiff alleges that she personally provided warning regarding the proximity of the heavy machinery to this valuable fixture. Did you, at any time, communicate this specific warning to your site supervisors?" Veronica leaned into the microphone, adjusting a diamond tennis bracelet that flashed under the studio lights. "Your Honor, my role is strategic oversight, not operational minutia. I hire professionals. If Miss Vance, who frankly appears rather disorganized, claims she spoke to a foreman, that is entirely between her and the contractor. My contract explicitly states that the contractor assumes all liability for site management and incidental damage." She punctuated the statement with a sharp, dismissive gesture toward Eleanor Vance, who flinched slightly. The implication was heavy. "I purchased immunity. Why are you bothering me?" Judge Wapner's pen hovered over his notepad, pausing. This was the opening he was looking for, not a legal technicality, but an admission of psychological distancing. "So you did not yourself visit the site during the initial excavation phase?" Wapner inquired, the tone neutral, almost inviting her to continue down this path of plausible deniability. Veronica smiled, a quick, practiced flash of teeth. "Of course I did, Your Honor. I visit daily. But I am inspecting the progress of the pool, not babysitting subcontractors or worrying about junk in someone else's garden." She used the word junk with deliberate cruelty, ensuring Eleanor heard it. Wapner watched this exchange, his gaze unblinking. He recognized the pattern immediately, the shield of delegated responsibility, the deliberate minimization of the plaintiff's suffering, and the subtle leveraging of her own social standing to imply that Eleanor was simply fabricating the importance of the item for financial gain. Wapner had seen this performance 1,000 times, perfected by those who believe the rules apply only to those without the resources to bypass them. This inherent belief in her own financial immunity was the core weakness Wapner was preparing to exploit. He knew that people who believe they are untouchable rarely bother to cover all their tracks, becoming lazy in their deceit. The smirk was a sign not of confidence, but of intellectual complacency. "Miss Thorne," Wapner continued, now leaning forward slightly, his voice dropping an octave, forcing the room to lean in with him. "You stated that your contract delegates all liability for site management to the contractor, Titan Earthworks, correct?"
"Absolutely, Your Honor. That is standard procedure for any project of this scale," Veronica confirmed, her voice regaining its confident, almost bored inflection. "And you are confident that the written contract submitted as evidence, Defendant's Exhibit B, accurately reflects that delegation of all liability for property damage." "I reviewed the contract myself. It's ironclad," she replied, offering a confident nod to her counsel, who offered a small, reassuring shake of the head. The contract. Veronica used her team to present a contract that, on its face, appeared to transfer all liability, successfully pushing the focus away from her direct culpability toward the construction company. This had previously stalled the case. But Wapner was not interested in the surface reading. He was interested in the unspoken conditions, the levers of control that wealth always maintains, even when pretending to delegate authority.
"I see," Wapner mused, picking up a separate sheaf of papers, a series of detailed construction schedules and alteration requests that had been filed late in the evidence chain. He did not look at Veronica. He studied the documents intently, letting the silence stretch into an agonizing duration. The smirk on Veronica's face faltered for the first time. The pause was too long. It violated the established rhythm of the proceedings. Wapner was supposed to accept the contract and move on to assessing the value of the sculpture. Instead, he was lingering, dissecting the ancillary paperwork. A tiny bead of perspiration formed just below her hairline. This was the re-engagement, the moment the complacent defendant realizes the referee is not observing the game, but actively participating in rewriting the rules. "Miss Thorne," Wapner finally said, looking up, his eyes now piercing, sharp, demanding singular attention. "You mentioned strategic oversight. In your deposition, you also mentioned several significant design changes implemented after the initial contract signing, specifically related to the depth and grading of the excavated area for the pool. Is that accurate?" "Yes, there were minor adjustments, standard design evolution," Veronica said, her voice tightening slightly. She tried to dismiss it, wave it away with a flick of her hand. "I expanded the footprint slightly. Nothing material to the immediate property line conflict." "Minor adjustments," Wapner repeated, his voice utterly devoid of inflection. He turned to the bailiff. "Bailiff, please present Defendant's Exhibit F, Item 3, to the defendant." The bailiff placed a thick, architecturally drawn schematic in front of Veronica. It detailed a massive subterranean filtration system for the infinity pool, an addition far grander than the original plans. Wapner continued, his delivery now gaining a relentless, methodical pace.
Thorne, Item 3 required the excavation team to deepen the pit by nearly 7 vertical feet and extend the dig 10 feet further west than originally planned. This specific alteration was requested by you personally on the Tuesday morning preceding the damage incident, correct? Veronica swallowed hard. Her rehearsed air of effortless control was beginning to crack, revealing the brittle anxiety beneath. She knew where this was headed. A design change of that magnitude required new machinery, more invasive procedures, and a revised schedule that would inherently push the boundaries of caution. I requested the alteration, yes, Your Honor, but the contractor was still responsible for executing the change safely. "Ah, but this is the crucial point, Miss Thorne," Wapner said, lifting up the contract document again, now focusing on a specific clause he had highlighted in red ink.
Your initial contract, which you claimed transferred all liability, explicitly stated that the contractor was responsible for managing the site as long as the work adhered strictly to the original submitted schematics. Veronica's gaze darted desperately to her counsel, who suddenly looked intensely uncomfortable. The lawyer had assumed Wapner would overlook the fine print, the microscopic legal asterisk that wealth always employs to maintain operational control. Wapner pressed the advantage, his tone now a low, dangerous rumble. "When you requested Item 3, this significant, late-stage, invasive alteration, did you submit a formal written addendum to the contract, indemnifying the contractor and transferring liability for any issues arising directly from your requested modification?" Veronica hesitated. This was the moment of ultimate truth, the fork in the road between arrogance and accountability. She could admit the procedural error, or she could try to lie her way past the judicial gatekeeper. Years of believing her status protected her dictated the choice. She looked Wapner directly in the eye, replacing the earlier casual smirk with a forced, rigid smile of confident fabrication. "Yes, Your Honor," she lied smoothly. "My counsel drafted the addendum and it was signed immediately." Wapner lowered the contract and stared at her, an expression of profound disappointment settling over his features. He did not challenge the lie immediately. He simply observed the hubris required to deliver it. "Bailiff," Wapner instructed, his voice now cold, flat. "Please present Plaintiff's Exhibit H, the full correspondence log between Thorne and Titan Earthworks, specifically focusing on the period between the design change request and the date of the incident." The documents were laid out.
Wapner did not wait for Veronica to review them. Miss
Thorne, Wapner continued, leaning back, the judicial trap now fully sprung. The court has in its possession an affidavit from Mr. Marcus Jennings, the CFO of Titan Earthworks, submitted late yesterday evening. Mr. Jennings states, under penalty of perjury, that while he objected to the sudden and invasive nature of the design change, no formal addendum regarding liability transfer was ever drafted or signed. Furthermore, he explicitly states that the contract required Miss Thorne to submit proof of a revised insurance binder to cover the expanded excavation, which she failed to provide. Wapner then delivered the final, crushing blow of this exchange, the words hanging heavy in the air, instantly extinguishing the last vestige of her calculated composure. In fact, Miss Thorne.
Thorne, the correspondence log shows a faxed message, time-stamped just 3 hours before the damage occurred, from your own legal assistant, acknowledging the omission and promising to draft the addendum the following week. This means, Miss Thorne, that when the damage occurred, the responsibility, the operational primary liability, rested not with the contractor, but with you, the party who mandated the precise action that led to the damage and who failed to complete the necessary legal steps to transfer that liability away. The room seemed to tilt slightly for Veronica Thorne. The forced smile vanished, collapsing inward, replaced by a sudden, ghastly paleness. The smirk had evaporated, instantly replaced by the terrifying realization that her carefully constructed legal immunity, the fortress built on layers of expensive legal maneuvering, had been demolished by one sharp, relentless judicial probe into the fine print she thought no one would dare read.
She had lied under oath about a document she believed Wapner couldn't disprove, and now the methodical Judge Joseph Wapner had exposed not just her liability, but her deliberate attempt at deception, setting the stage for a judicial reckoning she believed her wealth would always allow her to evade. The panic was immediate, pure and rising, tightening her throat and blurring the edges of the courtroom. The safety net she always assumed was beneath her had been suddenly and viciously pulled away, leaving her suspended over an abyss of public judgment. This narrative of exposure and the impending verdict continues in Part 2. The stark contrast between the gilded insulation of high society and the unvarnished reality of the small claims courtroom was never more palpable than in the ongoing matter before Judge Joseph A. Wapner. The defendant, let us refer to her as Ms.
Evelyn Davenport, a fixture of East Coast high finance and legacy philanthropy, continued to occupy her chair with an almost architectural rigidity. Her posture, designed over decades of private education and controlled social exposure, was meant to project effortless superiority, a silent yet deafening declaration that her presence here was a bureaucratic mistake, a temporary inconvenience soon to be remedied by the sheer weight of her pedigree. This cultivated indifference was the central theme of her defense.
She offered smiles that did not reach her eyes, subtle head tilts that conveyed benign confusion rather than respect, and answers carefully calibrated to suggest that the plaintiff's damages, which encompassed the destruction of a small but historically significant commercial property through reckless excavation on Davenport land, were merely collateral damage in the inevitable march of progress, or perhaps the unavoidable consequence of living too close to the son she represented. This approach, however, proved fatally miscalculated when facing the unwavering, meticulous gaze of Judge Wapner. The claim itself, initially presented as a standard tort of negligence, had quickly spiraled into something far more damning, an exhibition of deliberate, willful disregard for due process and communal safety. Part 2 of this courtroom drama focused heavily on the presentation of photographic evidence and engineering reports, documents that Miss
Davenport had clearly expected her high-priced legal team to sideline or dismiss through procedural maneuvers. In this informal setting, stripped of the typical delays and objections that characterize higher courts, the truth arrived with brutal, swift efficiency. The plaintiff, Mr. George Hemlock, a third-generation proprietor of a small antique bookbindery, had presented a series of dated blueprints and municipal permits dating back to 1958,
These documents clearly established a shared subterranean boundary and stipulated strict limitations regarding construction depth within a 5-meter buffer zone, restrictions put in place specifically due to the known instability of the underlying glacial till. Ms. Davenport's recent renovation project, a multi-million-dollar expansion involving the construction of an underground wine cellar and private art vault, had flagrantly violated these covenants.
Judge Wapner began his interrogation not with the damage itself, but with the specific mens rea, the mental state, of the defendant in authorizing the actions. He leaned forward, his voice a low, gravelly current of authority that immediately cut through the latent hum of the courtroom. "Ms. Davenport," Wapner began, referencing a thick binder of correspondence presented by the plaintiff. "On July the 11th of last year, did you receive a registered letter addressed personally to you from the Department of Municipal Infrastructure, explicitly warning that the depth of the proposed excavation, as detailed in your revised permits, posed a quantifiable and immediate risk to the foundations of the adjacent structure?" Ms. Davenport, adjusting the cuff of her silk blouse, paused, clearly calculating the safest path. "Your Honor, I receive hundreds of communications weekly. I rely on my property manager and my counsel to triage and address matters of maintenance and construction."
The smirk, though momentarily suppressed by the gravitas of the question, attempted a fleeting return, a subconscious assertion that managing her life was too vast an endeavor for her to be bothered with petty details like structural integrity warnings. It was here, at this precise juncture of deflection and implied superiority, that Judge Wapner applied the full force of his judicial temperament. "That is not responsive, Miss Davenport," Wapner stated, his tone chillingly level. "This was a certified letter marked Urgent Structural Hazard Notification. I see here the signature of your personal assistant, confirmed via notarized affidavit. The question is straightforward. Did you or did you not have direct knowledge of the imminent danger before the excavation breached the protected boundary zone?" The atmosphere instantly thickened. Miss Davenport's expensive veneer began to crack, replaced by a momentary flash of fear, the sudden, sickening realization that her standard corporate defense of plausible deniability was a paper shield against the judicial laser focus. She stammered, attempting to pivot the blame toward an abstract entity. "Your Honor, the initial contractors assured us that the geological surveys were conservative. We employed the best engineers money could hire." "Engineers who, I see, signed affidavits stating they advised against the depth increase," Wapner interjected smoothly, referencing another document without even looking down. "Your counsel provided these signed warnings to the plaintiff during discovery, which speaks volumes about your own staff's diligence, despite your apparent disregard for their warnings. Your defense hinges on the assertion that this was merely an unfortunate accident."
However, the evidence suggests something far more deliberate, a decision to proceed with a course of action you knew to be risky, simply because the cost of stopping, of redesigning your vault, was, in your estimation, higher than the potential liability. This was the first significant pattern interrupt. Wapner wasn't arguing about damages, he was arguing about intent. By establishing foreknowledge, he transformed the case from simple negligence into a potential claim of tortious interference and deliberate indifference, greatly escalating the liability ceiling and, crucially, undermining Miss Davenport's entire claim of immunity. The smirk vanished completely, replaced by a fixed expression of severe discomfort, the nascent stage of panic. Her hands, which had rested loosely on the table, now clenched tightly around the leather corners of her designer handbag. The detailed engineering reports followed. Mr.
Hemlock's representative introduced specialized geophysical imaging data showing that the foundational shift in the adjacent property occurred precisely 72 hours after Miss Davenport's crew initiated the unauthorized deep drilling for the western retaining wall. The presentation was technical, dense, and irrefutable. We were shown cross-sections illustrating the precise angle of deflection in Mr. Hemlock's century-old masonry caused by the lateral stress transfer. The estimated cost of stabilization and repair was staggering. Not merely the initial $60,000 claimed for property loss, but an additional $500,000 for structural remediation to ensure the building's continued viability and historical integrity. Wapner meticulously traced the timeline. He focused heavily on Exhibit D, a simple fax transmission sent from Miss Davenport's site foreman to her property manager, complaining that the client, Miss Davenport herself, had personally overridden the safety protocols to maintain the strict timetable for the impending holiday party debut of the new wing. "So, Ms. Davenport," Wapner pressed, allowing the weight of the evidence to settle. The foreman, Mr. Rourke, testified in his deposition that he was explicitly told by your authorized representative that any delay, even for safety checks required by the municipal notice, would result in the termination of his contract. Is that an accurate reflection of the urgency you imposed? I was merely interested in adherence to the schedule," she responded, her voice strained, losing her habitual melodic smoothness. "Construction schedules are notorious for delays, Your Honor. I expected competence." "And when competence meant stopping the work to prevent structural failure next door, you incentivized incompetence?"
Wapner countered, delivering the sentence not as an accusation, but as a clinical observation of operation. Wapner countered, delivering the sentence not as an accusation, but as a clinical observation of operational fact. You weighed the marginal cost of a one-week delay against the potential loss of life and property next door, and you chose the schedule. Is that the testimony you wish to stand upon? The courtroom was silent, suspended in the unbearable tension of a privileged individual being forced to confront the moral calculus of their decisions in public. Ms. Davenport's wealth, usually the ultimate resolver of problems, was proving utterly useless against the simple, unyielding logic of physics and legal precedent being deployed by Judge Wapner. The secondary thrust of Ms. Davenport's defense was the attempted devaluing of Mr. Hemlock's property. Her legal team had prepared voluminous documentation suggesting that the bookbindery was functionally obsolete, arguing that market valuation for the structure was negligible and therefore the compensation should be minimal, enough to satisfy the debt but not enough to financially punish the defendant. They essentially argued that she only damaged a building that should have already been torn down. This was the precise moment Wapner introduced the concept of sentimental and historical value within the context of liability for deliberate destruction. He referenced a seldom-cited 1968 ruling concerning the liability of developers who knowingly compromised landmark structures, a ruling that established a compensatory multiplier when reckless development damaged properties deemed essential to the local cultural fabric. Mr. Hemlock's business, Wapner stated, turning his attention to the plaintiff, who sat pale and quiet, has been in continuous operation since 1922.
It housed unique, irreplaceable presses and specialized equipment. Ms. Davenport's representation suggests we look only at the current real estate market value of the building. But the law, Ms. Davenport, often looks deeper, especially when the damage arises from actionable negligence. We are not compensating for a simple structure. We are compensating for the irreversible loss of an ongoing historical enterprise, the cessation of which was directly precipitated by your conscious choice to prioritize personal vanity over civic duty. This line of judicial reasoning completely decimated Miss Davenport's financial strategy. She had budgeting for a low six-figure settlement, a cost of doing business. The introduction of historical compensation factors, coupled with the clear finding of deliberate indifference, suddenly propelled the potential liability into the high seven figures, perhaps even crossing into punitive territory. The shift in Miss Davenport's demeanor was now total.
Her former smirk had evaporated, replaced not just by discomfort, but by visible anxiety. Her breathing became shallow and fast. She began nervously running her thumb across the metallic clasp of her purse, a repetitive, involuntary gesture indicating deep internal distress. The reality was settling in. Her meticulously constructed fortress of financial and social immunity had been breached not by an aggressive, biased prosecutor, but by a calm, meticulous judge armed only with facts and precedent. The narrative of her defense, that she was merely a victim of overzealous subordinates and complex engineering issues, was systematically incinerated by her own authenticated correspondence. Judge Wapner, acting as both fact-finder and dispenser of law, was forcing her to own the decisions she had tried so hard to delegate away. The ultimate conclusion of the financial reckoning remained tantalizingly just out of reach, but the foundation for a devastating judgment had been firmly laid.
She now understood that she was not just facing a monetary loss. She was facing a public, documented finding of willful ethical failure, a stain that even her vast wealth might not easily bleach away from her public reputation. The anticipation of the final ruling and the quantum of damages Wapner would assign hung heavy and ominous in the air, transforming her sophisticated anxiety into genuine, creeping dread. The court was preparing the final evidence summation, and Miss Davenport knew, with gut-wrenching certainty, that the tide had irrevocably turned against her perceived right to be above consequence. The air in the courtroom had solidified into an almost painful density, a byproduct of the calculated legal warfare mounted by the defense. Mr. Sterling, the impeccably tailored attorney representing Veronica Hayes, approached the lectern not with the fervor of a believer, but with the cool detachment of a surgeon about to perform a complicated yet routine procedure. His objective in this critical juncture of the proceedings was clear: to leverage the sheer complexity of the modern judicial system to drown the plaintiff's fundamentally simple claim in an avalanche of technical minutiae and expertly crafted ambiguity. Sterling began by introducing the first of his 5 planned expert witnesses, Dr. Alistair Finch, a forensic accountant whose credentials, meticulously enumerated, spanned 3 continents and nearly 2 decades of litigation support for Fortune 500 companies. Finch's testimony was a masterclass in obfuscation. He presented detailed projections, regression analyses, and comparative market metrics designed to drastically deflate the value of the plaintiff, Mr. Thompson's, claimed losses.
The defense was not denying the incident had occurred, but rather arguing, through layers of financial jargon, that the resultant damages were economically negligible, grossly exaggerated, or, most critically, attributable to pre-existing market conditions entirely independent of Ms. Hayes' actions. Dr. Finch spoke of diminished asset valuation relative to cyclical market troughs, utilizing graphs projected onto the courtroom screen that were aesthetically beautiful but analytically impenetrable to the layperson, and seemingly designed to induce intellectual fatigue in anyone not equipped with an MBA. Veronica Hayes watched this display with renewed confidence, her faint smirk returning, now underpinned by the undeniable weight of sophisticated data. This was the fortress her money had built, a legal wall too tall, too complex, and too expensive for a simple man like Thompson to scale.
Wealth, in her mind, was not merely possessing capital, it was the ability to deploy intellectual firepower that made the very concept of objective justice irrelevant. However, Judge Joseph Wapner, observing the theatrical display from the elevated bench, was visibly growing impatient. His posture, initially attentive, had become rigid, characterized by a slight forward lean and the slow, deliberate tapping of his pen against a legal pad. This was a classic Wapner indicator, the transition from judicial observation to imminent, sharp intervention. When Sterling concluded Finch's testimony and smugly offered the witness for cross-examination, Wapner interjected before the plaintiff's counsel could stand. "Mr. Sterling," the judge's voice cut through the air, low but resonant, devoid of the theatrical flair of the attorney, but carrying infinitely more authority. "Dr. Finch has provided us with a truly exquisite demonstration of computational modeling."
I believe he mentioned hedonic pricing metrics no fewer than 7 times. Let me ask you this. When all the regressions and metrics are stripped away, are we not simply discussing the market value of a man's property and his ability to work? Sterling, momentarily flustered by the judicial detour, attempted to recover his calculated pace. Your Honor, with respect, the court must consider the full scope of economic factors. To assess the claim based purely on sentiment or baseline replacement cost would be to ignore established financial protocols. We are arguing that. You are arguing that the injury sustained must be filtered through a complexity machine so profound that the human cost vanishes. Wapner finished, his gaze fixed piercingly on Sterling, then briefly flicking to Veronica Hayes, whose smugness momentarily wavered under the unexpected judicial scrutiny.
I understand the methodology, counsel.
I do not necessarily accept the premise that complexity supersedes common sense, particularly in this forum. Dr. Finch, you are excused. The court will give your spreadsheets due consideration, but I must warn you, Mr. Sterling, that this court values the truth of the transaction, not merely the sophistication of the financial narrative designed to obscure it. This interjection served as the first major pattern interrupt in the defense's carefully constructed strategy. It signaled to everyone present, especially Veronica, that Wapner was not a passive recipient of legal theater. He was an active interpreter of reality. The defense pressed on, moving to their accident reconstruction expert, a specialist whose testimony aimed to introduce the technical possibility of comparative negligence. The meticulous discussion of skid marks, kinetic energy transfer, and reaction times was designed to shift some portion of the blame onto Mr. Thompson, suggesting that even if Miss
Hayes was speeding, a more alert or faster reacting driver could have mitigated the catastrophic consequences. It was during this highly technical phase that the plaintiff's attorney, seizing the window opened by Wapner's earlier impatience, initiated a devastating line of cross-examination. Instead of challenging the expert's physics equations, the attorney focused entirely on the expert's assumptions. "Sir," the plaintiff's counsel inquired, "your analysis is premised on the assumption that Mr. Thompson had a reaction time of 1.5 seconds, correct?" "Based on standard industry models, yes," the expert confirmed confidently. "And your analysis also assumes a clear line of sight for him, correct?" "Yes." "And yet your report provided to the court clearly notes that Miss
Hayes's vehicle was an extremely distinctive modified luxury car, a vehicle designed not for pedestrian driving, but for high-speed performance and aesthetic impact, often drawing the gaze of other drivers, correct?" The expert hesitated. "That is subjective. Its design is performance-oriented." "Subjective, perhaps, but relevant to the human factors involved," counsel pressed. "Your entire reconstruction rests on mathematical perfection that ignores the fact that Mr. Thompson, a human being, was likely startled, distracted by the spectacle of the oncoming vehicle, or simply unable to react to a speed far exceeding the posted limits. Is it not true that even a fractional deviation in human reaction time, caused by the defendant's specific, highly aggressive driving profile, nullifies the concept of comparative negligence entirely?" The tension ratcheted up further. The defense expert, trained to argue physics, struggled against an attack focused on psychology and human error.
Veronica Hayes, observing this exchange, shifted uncomfortably. This wasn't the clean, sterile litigation her lawyers had promised. The human element, the thing her wealth was supposed to sanitize, was stubbornly reasserting itself. The true escalation began when the court turned to the matter of Miss Hayes's own testimony. Sterling, wary of Wapner's temperament, attempted to keep her answers monosyllabic and rigidly controlled. He led her through a carefully rehearsed narrative. She was rushing due to an urgent business matter. She deeply regretted the outcome. She relied entirely on her team for damage assessment. Wapner intervened again, fixing Veronica Hayes directly with his gaze. "Miss Hayes, you have testified that you regret the incident. I have reviewed the police report, which notes that immediately following the collision, you placed a call to your personal insurer before exiting the vehicle to assess the damage or check on Mr. Thompson. Can you confirm the sequence of events?" The question was a judicial probe, direct and excoriating. It bypassed all legal maneuvering and went straight to the issue of moral responsibility and immediate priority. Veronica, used to answering questions about board meetings or investment portfolios, stumbled. "Your Honor, I was disoriented. My immediate thought was to ensure the situation was handled professionally, according to my insurance requirements." "Handled professionally," Wapner repeated, his voice dangerously even. "Meaning the protection of your own assets took immediate precedence over the welfare of the man whose livelihood you had just jeopardized. Is that an accurate summary of your split-second priority calculus?" The question hung in the silence like a physical weight. Veronica looked desperately at Mr. Sterling, who offered a subtle shake of the head. "Do not elaborate."
"I was simply acting responsibly, Your Honor," she whispered, her voice losing its previous cultivated timbre. "Responsibility takes many forms, Miss Hayes," Wapner stated, making a notation on his pad that seemed to seal a portion of her fate. "Moving on, Mr. Sterling. The plaintiff has submitted evidence relating to a social media post made by Miss Hayes approximately 20 minutes prior to the incident concerning her driving habits. This was the bombshell the defense had fought tirelessly to suppress, a truly damaging piece of evidence that transformed the incident from an unfortunate accident into a potential act of willful negligence. The post, a casual, contemptuous remark made on a closed platform, referenced her high-speed commute and contained a flippant phrase about the inconvenience of speed limits designed for the hoi polloi. Sterling immediately leaped to his feet. "Objection, Your Honor." "Prejudicial, speculative, and entirely irrelevant to the physical facts of the collision. It is an unverified personal comment." The defense is aware that the platform authenticated the timestamp and authorship of the post during discovery, Wapner countered, dismissing the objection with an impatient wave of his hand. The court deems it highly relevant to the defendant's state of mind, intent, and attitude towards traffic laws immediately preceding the incident. It directly impacts the discussion of recklessness. Ms. Hayes, I want you to confirm the contents of this post for the record. Veronica's pale complexion turned a shade whiter. The smirk was now utterly gone, replaced by a nascent terror. Her previous belief in her immunity, the conviction that her money could filter reality, was dissolving under the harsh, unyielding light of judicial scrutiny. She realized with a sickening jolt that Judge Wapner wasn't merely applying the law. He was applying the law through a filter of ethical expectation, a factor her expensive legal team had failed to anticipate. They had prepared for a legal skirmish, but Wapner was waging a moral audit. For the next half hour, the proceedings devolved into a tense, highly detailed argument over the admissibility and interpretation of this digital evidence. Sterling argued precedent, the definition of intent, and the dangers of judicial overreach based on non-substantive digital chatter. The plaintiff's counsel argued that the post proved a pattern of contempt for the rules of the road, establishing a predisposition for the exact reckless behavior that caused the injury. Wapner listened with visible concentration, reviewing case law cited by Sterling with meticulous care, underlining passages with a heavy stroke. The court observed the extraordinary spectacle of a high-powered, high-cost defense team sweating profusely as they tried to convince a common-sense judge that what a person thinks and broadcasts 20 minutes before an incident has no bearing on their actions. Finally, Wapner slammed his hand lightly on the bench, back to Veronica, who was now gripping the sides of the witness stand, her composure utterly fractured. She was not panicking yet. That required the final judgment, but she was entering the chilling realization that her protective bubble had burst. Wapner leaned forward, his expression grave. "Ms.
Hayes, the court needs to understand the depth of your actions beyond the simple physics of the collision. We have seen the evidence of your attitude, the immediate prioritization of your insurer over the victim, and the voluminous, though ultimately unpersuasive, technical arguments presented by your counsel to minimize the financial impact. Now, I require the documentation related to the repair timeline of your own vehicle following the incident." This was another unexpected pivot, a tactical masterstroke that tied the financial complexity back to the defendant's personal conduct. The defense had only submitted repair costs for Mr. Thompson's vehicle. Sterling looked genuinely shocked. "Your Honor, the state of the defendant's vehicle is irrelevant to the plaintiff's damages claim." "On the contrary, Mr. Sterling, the speed and quality of the repair of Ms. Hayes's vehicle speaks volumes to the urgency and priority placed on restoring her life to its previous unencumbered status versus the prolonged disruption suffered by the plaintiff. It is material to understanding the totality of the disparity in the response to the accident. I want to see the service records, the payment receipts, and the full timeline from the collision date to the date her vehicle was returned to her. I want this information produced for the court's review by the resumption of tomorrow's session." Wapner's demand was not merely procedural, it was a psychological checkmate. The defense had painstakingly documented every metric except those relating to Veronica's privileged immediate recovery. This information, if disclosed, would inevitably show an expedited, expensive process completed while Mr. Thompson was still struggling with insurance forms and rental cars, a visual, undeniable manifestation of the very immunity she believed she possessed.
The judge's expression, severe and unwavering, left no room for appeal. Veronica Hayes stared at the bench, her mouth slightly agape, recognizing for the first time that the true threat in the room was not the plaintiff's attorney, but the man in the robe whose moral compass was utterly impervious to the influence of her vast wealth. The development phase had concluded, leaving the courtroom perfectly poised on the precipice of judgment, with the defendant's carefully constructed fortress of arrogance reduced to a pile of shattered legal precedents, awaiting the final, inevitable hammer blow of Judge Joseph Wapner's decision. The chamber air, thick and still, settled into a profound, almost paralyzing quietude, broken only by the mechanical hum of the overhead lights and the soft, repetitive tap of Judge Joseph Wapner's pen against the polished wood of his bench.
Eleanor Vane, having successfully navigated what she perceived as the trivialities of the testimony, her brief, practiced condescension intact, sat rigidly upright, a perfectly manicured embodiment of expectation. Her expression, which had oscillated between mild annoyance and a deeply ingrained, patronizing confidence, signaled an absolute belief that the forthcoming judicial monologue would merely be a procedural formality preceding her inevitable, if slightly irritating, acquittal. The legal strategy employed by her high-priced counsel had been ruthlessly effective in obscuring the simpler moral core of the dispute, burying the facts under a monumental mound of procedural jargon, jurisdictional nuances, and calculated character assassination directed at the plaintiff, a man whose quiet dignity spoke volumes that Vane had repeatedly chosen to ignore. Wapner, however, was not reading his notes. His gaze, steady and unflinching, swept slowly over the courtroom, lingering first on the plaintiff, the quiet proprietor whose life's work had been summarily dismissed as collateral damage, and then, with devastating precision, fixed upon Eleanor Vane. There was a palpable shift in the atmosphere. The easy, almost theatrical rhythm of the proceedings suddenly vanished, replaced by the heavy silence of imminent consequence. This was the precise moment the judicial veneer dissolved, revealing the unyielding steel of Wapner's commitment to rudimentary fairness. He leaned forward, resting his forearms on the bench, an imposing posture that demanded not just attention, but absolute submission to the gravity of his words. He began not with a summary of the evidence, nor the financial damage, but with a precise, cold appraisal of the defendant's conduct. "We have spent considerable time listening to your expert testimony, Mrs. Vane. Testimony that has attempted, quite desperately, and I must say quite unethically, to transform a clear-cut case of wanton negligence into a complex failure of the plaintiff to adequately mitigate losses that were in fact entirely caused by your actions. This court has heard much about depreciation schedules, about high-end property values, and the meticulous legal choreography of corporate insulation. But what this court has not heard is a single syllable of remorse or even a basic acknowledgement of human accountability." This was not the dry technical ruling she expected. This was a public judgment of her character, a frontal assault on the very foundation of her assumed immunity. He continued, articulating the foundational flaw in her legal defense, the belief that extraordinary wealth provided a shield against ordinary standards of conduct. Your failure to institute basic mandated safety protocols, documented extensively in the plaintiff's exhibits, protocols that would have cost a mere fraction of your monthly expenditures, was not an oversight. It was a conscious choice, born of convenience, of disdain, and of a fundamental belief that any potential consequences could be managed, or simply absorbed by the injured party without substantial recourse. He detailed point by painstaking point the evidence her team had tried to minimize: the structural integrity report, the ignored municipal warnings,
the cavalier deposition responses where Eleanor had casually dismissed the plaintiff's losses as a minor inconvenience to my schedule. Each citation was a nail hammered into the coffin of her defense, stripping away the layers of pretense. The plaintiff suffered damages amounting to far more than the tangible loss of property. He suffered the obliteration of legacy, the cessation of livelihood, and the profound stress of watching years of dedication be reduced to rubble, all while navigating the hostile legal environment created by your refusal to accept the most rudimentary responsibility.
The defense insists on limiting the recovery to the raw market value of the physical damage, ignoring the consequential damages of business interruption, emotional distress, and the sheer audacity of forcing this matter into litigation when the liability was obvious from the outset. This court will not participate in such a willful distortion of justice. The smirk Eleanor had carried like a signature accessory finally shattered. It was not a sudden, dramatic explosion of emotion, but a slow, agonizing process. Her eyes widened slightly, the realization dawning that the judge was systematically dismantling not just her case, but her worldview. The color drained from her cheeks, leaving the meticulously applied makeup stark against the sudden pallor of genuine fear. Her attorney, a man accustomed to manipulating weak judges, leaned over and whispered a frantic instruction, urging her to maintain composure, but Eleanor was trapped, transfixed by the judicial monolith before her.
Wapner reached the pinnacle of his decision, the inflection point where financial compensation transcended mere repayment and became punitive justice. He addressed the open loops that the defendant's strategy had intentionally created, the deliberate confusion over asset tracing, and the attempts to paint the plaintiff as greedy. The attempt by the defense to hide behind layers of corporate shell companies, the Vane Holding Group LLC, the Silverstream Trust, the various offshore entities, is noted and it is rejected. This court views the various shell entities as extensions of the principal actor, Mrs. Vane, designed solely to complicate legal remedy and frustrate the ends of justice. The deliberate opacity of these arrangements is not a defense. It is an aggravating factor, demonstrating calculated malfeasance. Wapner paused, lifting a sheet of paper. The air in the courtroom seemed to solidify.
This was the moment of reckoning, the transition from philosophical reprimand to concrete financial devastation. The plaintiff's claims for hard damages, including replacement costs, business interruption losses, and the verifiable costs of mitigation, totals $485,000. This court finds that amount to be entirely justified and warranted. Eleanor's exhale was barely audible, a quick, sharp gasp of relief. $400,000, while substantial, was a manageable inconvenience. She briefly regained a fraction of her earlier arrogance, a small, bitter flicker of triumph. But Wapner was not finished. His voice hardened, achieving a pitch of controlled fury that silenced any residual murmurs in the gallery.
However, due to the demonstrably egregious nature of the defendant's conduct, the systemic negligence, and the calculated unnecessary hostility displayed throughout the discovery and trial phases, actions clearly intended to leverage financial inequality to deny justice, this court finds that standard restitution is wholly inadequate. Justice, when mocked, must possess a decisive deterrent quality. He brought the gavel up, hovering it momentarily over the sounding block, a gesture heavy with unspoken finality. Therefore, exercising the full discretionary latitude afforded to this bench, and to establish the unequivocal principle that wealth confers no immunity from basic human decency or legal accountability, this court assesses punitive damages against the defendant Eleanor Vane in the amount of $600,000. The word $600,000 landed like a physical blow. Total judgment, $1,085,000.
The effect on Eleanor Vane was immediate and visceral. The controlled mask of entitlement dissolved into pure, uncontrolled terror. Her eyes, moments before cold and calculating, now swam with panic. It was not just the financial blow, which, though painful, was absorbable.
It was the sheer humiliation of being judged, not just guilty, but vile, in a public forum, stripped of her assumed superiority. The gavel descended with a sharp, resonant crack that echoed the finality of the decision, an exclamation point on the collapse of her self-constructed reality. The room swam into motion. The plaintiff, who had sat stoically through months of litigation, bowed his head, a single, silent expression of profound relief. Eleanor's lead counsel, a sharp, expensive man named Harding, immediately attempted to salvage the situation, scrambling to his feet to address the bench. Your Honor, with respect, the punitive assessment is excessive and entirely unwarranted by the statutory parameters.
We intend to file an immediate motion for reconsideration and seek appellate review on the punitive findings. Wapner did not even look at him. His attention remained fixed on Eleanor Vane, who was now clutching the edge of the defense table, visibly trembling, her breath coming in ragged, shallow gasps. The smooth, rehearsed confidence was gone, replaced by the raw, exposed vulnerability of someone who had just understood the true meaning of consequences. The sight was startling, the transformation of a carefully maintained facade into genuine, unadulterated distress. Her pale complexion flushed scarlet, then returned to a sickly gray. Counsel, Wapner stated, his voice now calm but utterly immovable. Your intention to appeal is duly noted, and it is your right. However, let the record reflect that this judgment is grounded in overwhelming evidence of calculated indifference, and the punitive measure is directly tied to the financial capacity of the defendant to absorb and, frankly, laugh off any lesser penalty. The measure is warranted. Your objection is overruled. He offered a final, piercing commentary that served as the concluding lesson for every viewer, for every litigant, and especially for Eleanor Vane, whose panic was now escalating into a full-blown state of shock. Mrs. Vane, the judge began, his tone now almost professorial, concluding the lesson he had been teaching since the case began. You operated under the grave yet common delusion that the acquisition of extraordinary wealth somehow elevates one above the constraints of common law and moral obligation. You assumed your resources would buy you immunity, obfuscation, or at the very least a negotiation of minimized responsibility. You were mistaken.
This court, and indeed the entire legal framework of this nation, is predicated on the simple, immutable principle that justice is blind, and it does not weigh the size of the bank account before determining culpability. The rule of law applies universally, without deference to pedigree or economic status. He gathered his papers, the subtle rustle sounding immensely loud in the hushed courtroom. The gavel rested firmly on the block. The sight of Eleanor Vane, reduced from smirking superiority to pure, undignified panic, her eyes darting around the room, desperate for an escape route that did not exist, was the definitive image of the day. Her immunity had expired, revoked by the unwavering authority of the court. The wealth she so proudly flaunted had not shielded her. It had, in fact, increased the cost of her negligence. The judge rose, the movement signaling the absolute end of the proceedings. Court is adjourned.
The sound of the courtroom doors swinging open provided the final, humiliating exposure for Eleanor Vane. She was forced to navigate the gauntlet of the public and the cameras, no longer the untouchable heiress, but a convicted defendant, stripped of her bravado, her panic a transparent, involuntary performance for the world to see. The smirk was gone, replaced by a devastating recognition of her profound vulnerability under the impartial eye of the law. The case of Vane versus the proprietor became an immediate and enduring symbol of televised justice, a potent reminder that, in Judge Wapner's court, the ultimate currency was not offshore capital or social standing, but verifiable truth and demonstrable accountability. For Eleanor Vane, the $1 million judgment was merely the tuition fee for the harshest lesson of her privileged life, that the cloak of wealth provides surprisingly thin insulation when confronted by the blunt force of true, unwavering judicial conviction.
The panic she felt in that moment was the sound of her self-made fortress crumbling. This specific and highly publicized demonstration of judicial equity serves as a critical counterpoint to the pervasive narrative of the powerful perpetually escaping accountability. To delve deeper into the philosophical underpinnings of courtroom accountability and how figures like Judge Wapner established precedents for accessible justice, ensure you follow this developing narrative and explore the subsequent analyses of this pivotal case.